want to introduce our moderator for the second panel. So just to give us a headline for what you heard on the first panel, I think on the first panel we heard a mix of some of the current concerns around the privacy framework that we're currently dealing with, potential unintended consequences may occur, particularly for underserved communities. And I think that last part of the discussion that really got into some of the possible issues as related to people's personal identity and how that could be profiled for future use was also something I think that hit a note in that last conversation. So now we want to turn it over to people who are working on the policies here in Washington, D.C. around privacy and hear a little bit about what they're doing and how they're going to address some of the concerns. And for those of you that just joined us, one of the questions that the Joint Center has placed out there as part of the aha moment for this panel is how can we really avoid any unintended consequences for communities of color that are going to be new adopters to the Internet. So I'm going to turn it over to our moderator for this session, which is Carolyn Brandon, who is Senior Industry and Innovation Scholar at Georgetown Center for Business and Public Policy. Ms. Brandon joined Georgetown Center for Business and Public Policy as a Senior Industry and Innovation Fellow in July 2009. Immediately prior, she was Vice President for Policy for CTIA, the Wireless Association, where for 5 years she'd worked with wireless service providers, OEMs, and other CTIA member companies for around developing strategic national public policies for the U.S. commercial wireless industry. Prior to that, she was a partner in a major law firm where for 12 years she represented wireless telecommunications providers in proceedings and transactions before the FCC, State Public Utility Commission, U.S. Bankruptcy Courts, and the U.S. Securities and Exchange Commission. Ms. Brandon was voted in 2008, I'll just read this part about your girlfriend, the top 10 women in wireless in 2008 by Wireless Week. She knows this topic. She's really engaged in ensuring that communities of color are served, which is why we at the Joint Center selected her to moderate this panel. So without further ado, let me introduce Carolyn Brandon.
And I think what we're going to do is we're going to dispense with long opening statements, and we're going to go ahead and organize our thoughts by hearing from each of our speakers around what's currently pending and in play at their relevant agency, on their relevant committee, and or with their particular member. And I'm very, very, very honored to have been asked to moderate this particular panel because we are joined by really the who's who that are making some of these very significant policy decisions here in Washington these days. We are joined by Mark Baraka, who is Senior Policy Advisor at the U.S. Department of Commerce, Jonathan Donenberg, Chief Counsel, Office of U.S. Senator Richard Blumenthal, Josh Gottheimer, Senior Counsel, the Federal Communications Commission, Tim Robinson, who is Senior Policy Counsel and Legislative Director, Office of U.S. Congressman Bobby Rush, Danny Sepulveda, who's Senior Advisor to U.S. Senator John Kerry, and last and certainly not least, and very happy to be joined by a woman up here, is Catherine White, who is with the Bureau of Consumer Protection at the Federal Trade Commission. So without any further ado, and Danny, simply because you're closest to me, can you share some thoughts as to what's currently pending in your world in terms of legislation that's currently out there and any legislation that might be coming down the pike in the near future?
Okay, first of all, thank you all very much for having us. I want to thank the Joint Center for having us. I started my career at the National Council of La Raza as an advocate for low-income Latino communities, so the Joint Center's mission is near and dear to my heart. In terms of pending legislation, I think that the last panel did an excellent job, Link and Eric, of going over what is the Kerry McCain bill in particular, but there are also other pieces of legislation that the previous panel talked about, do not track, and I think there's a lot of thought and discussion around data security and children's issues related to the collection of information. So that's what's in front of us. I'm happy to answer any questions that you all might have, and I also want to make sure that Brother Robinson over there is given a shout out because our work is largely derivative of what came out of Bobby Rush's work, and that was to some degree derivative of the past work that Mr. Hollings did and the Fair Information Practice Principles discussions that have taken place since. So I think we're all trying to aim to do the same thing, which is to put the Fair Information Practice Principles into practice and make sure that everyone who collects information on folks respects those people and ensures that their information is secure and that they're active participants in how their information is managed.
Thanks, Danny, and thanks to Nicole and Carolyn for their efforts in this space, and also the Joint Center for their focus on what I think is a very important and obviously emerging issue for all of us as the society becomes more digital in its orientation. I would refrain from attempting to describe or give you greater detail on any of the sort of good work that Danny and Tim have done for a number of years now. With their in their respective spheres. Senator Blumenthal is obviously new to the show in D.C., but is not new to these issues, and I think came here in part with a desire to really work on a lot of to translate some of his experiences in this space into federal legislation. Just learning what an interesting experience that can be. A few things that I would just sort of flag quickly before pushing it down the line that maybe haven't been talked about as much. One is obviously something that there has been a lot of conversation around, and which I know Tim and Congressman Rush have worked on a lot, are the data breach issues, and I think in particular questions of accountability and incentives for companies to do a better job of protecting consumer data. So we've seen, a raft of data breaches across sectors, and in a lot, and obviously, the proximate criminal is the hacker, and we need to deploy all the resources that we can to go after those folks. But a number of experts have flagged the sort of lack of sufficient incentives for some of these companies to develop, sort of minimally adequate security procedures in order to safeguard that data. And obviously, you're never going to be able to completely deter or eliminate, hacking. But I think there's been a lot of discussion in previous Congresses, and it continues today, about how do we design sort of minimum standards and how do we ensure that those standards are enforced across the space. So that's something that I know that we're looking at closely. Another area which CDT has been involved in is mobile data location privacy. So, there's a proliferation of these devices now. I mean, I'm walking around with 2 of them, and it's only sort of recently starting to become apparent that they, are that the interaction between those and the GPS device inside of the phone and the sort of Wi-Fi mapping technology is allowing these companies to kind of track your movement at any given moment. And the existing legal regime, which I know Justin talked on a bit before, which is a sort of a hodgepodge of statutes that were written before anyone ever conceived of an iPhone. And there's a lot of focus. I know Senator Franken and Senator Blumenthal in the Senate and some others as well, Senator Wyden, have looked into what can we do to do a better job of ensuring that individuals have the opportunity to give consent before their location information is broadcast. This is a particular issue of concern in terms of violence against women. There are these sort of so-called stalker applications that you can download onto somebody's phone that will kind of broadcast their location without telling them. So, ways to sort of deal with those issues. And then just the other kind of category that I'd briefly touch on, which Catherine is maybe more qualified to talk about, but there is sort of there's been the emergence of kind of social media data mining. So, we think of the credit rating agencies and their traditional, what they traditionally do, the piece in the Washington Post that Justin talked about with these sort of fourth bureau agencies that collect up additional information, on people and background checks. And then, there's the emergence of sort of even further afield from that, companies that are kind of digging through Facebook profiles and LinkedIn profiles to put together a lot of information about individuals that can also be used in employment or in consumer credit decisions and these sorts of things. And the questions of how the existing legal regimes are kind of imperfectly matched up to deal with with that situation, to ensure that there's a focus on accountability and individual consent and choice, and how do you correct flaws in that record, and what sort of information should be off limits for being included in those sorts of profiles. I think that's another area that we're focused on.
Thank you. So at the FTC, we're just continuing on with our business as usual. So we've got our law enforcement mission, which we still, we bring cases, data security cases, Fair Credit Reporting Act cases, and Section 5 unfairness cases that mostly deal with privacy and issues and deceptive privacy policies, people who aren't following the guidelines they tell consumers they are with respect to the collection and use of information. In December of this year, the staff of the FTC put out sort of a preliminary privacy report where we put some recommendations for guiding a discussion of privacy out. And have now collected all the comments, public comments, and are going through it. So that's sort of a big policy project we have going on. And finally, consumer education is something we're still very actively pursuing. We think consumers understanding the technology that's out there, understanding their privacy choices, knowing what sort of potential pitfalls there are for certain choices, how to avoid scams is something we've been trying really hard to partner with other organizations to make sure that all the consumers sort of have this basic education. So we've been working on our site On Guard Online, which is a partnership with other law enforcement agencies to really give a good overview of the internet and other technology. You know, what's a mobile app? How does it work? What should you think about before you decide if you want to download this one, use this one? So we've been really actively pursuing that as well, the consumer education aspect. But there's always some new issue at the forefront, and so it's never a boring place to be. But our basic, concern always remains the same, which is making sure that privacy is being adequately protected as part of the consumer protection mission we have.
Thank you, Catherine. I'm Mark Borreka. I'm from the Department of Commerce, and I want to heap on the praise to the Joint Center for doing this work. I know the Joint Center gets into a lot of different tech policy issues, and I think it's super important to bring your perspective into the conversation. At the Commerce Department, we historically have played a fairly substantial role in the development of the U.S. government's view on privacy policy. That dates back to what I consider to be the birth of internet issues, at least public policy issues in the internet realm back in the late 90s. At that time, the White House, the Commerce Department, and the FTC joined forces to lay out a largely unregulatory framework for dealing with internet issues. Over the course of time, pieces of legislation have been adopted. There's been a child's privacy protection. There have been efforts to regulate internet content that have fallen by the wayside as a result of Supreme Court decisions. There have been digital signature laws, et cetera. You could say that over the last decade, Congress and regulators have taken on internet issues in sort of a piecemeal fashion. Under the Obama administration and the leadership of Secretary Locke, we've tried to reinvigorate the Commerce Department's role in looking at internet privacy writ large, and one of our primary areas of focus has been data privacy. Our first major step in the data privacy realm was to issue what we call a green paper last December, and by green paper we mean it's fresh, it's not yet mature. Basically, it proposed a new look, a new way for dealing with privacy issues now that the internet has matured. And then that green paper evolved further to the point where by March, our General Counsel, Cam Carey, was able to testify before Congress and call for, on behalf of the administration as a whole, to call for baseline privacy legislation. So this is pretty significant step for the administration. There hadn't been an administration call for baseline privacy legislation going back to the end of the Clinton administration, when Bob Potofsky, then chairman of the FTC, called for legislation. So 10 years later, there we were as the Commerce Department saying that the time had come. And in large measure, the views we articulated in that testimony in March align well with a lot of the work that's going on in this Senate Commerce Committee, starting with codifying the Fair Information Practice Principles. Looking ahead, our green paper and our deliberations are now being aired within the administration as a whole, with the hope that before the summer is out, the White House will be issuing an administration-wide view on data privacy. So we will have moved the conversation from a Commerce Department proposal to a White House-endorsed position on data privacy. One of the main one of the main contributions, aside from calling for legislation, that we believe we've baked into the Green Paper and are evolving through our ongoing deliberations, is this notion that something has to sit atop the baseline privacy principles to provide consumers and industry guidance when it comes to specific categories of privacy issues. That there's not a lot of value to be had in having standalone laws or regulations for mobile applications, or standalone laws and regulations for social media, standalone laws and regulations for category X, Y, or Z, of these new categories of issues that seem to crop up on a regular basis. But instead, and this is the new contribution, instead, for each of these new categories, the government can help convene stakeholders and bang out codes of conduct or best practices that the industry players would then sign up to, and in turn those codes could be enforced by the FTC. As we see it, that's a much more nimble process. Key to the success of that process, though, will be to have true multi-stakeholder participation. So it will be important for organizations that represent older people, organizations that represent other disadvantaged groups, to be part of that multi-stakeholder process, so that as we develop a code for mobile applications, or a code for social networking, or a code of conduct for some other category of privacy issue, all voices are represented. I think the last thing I'd throw in is picking up on Jonathan's comment about data breach. The administration has also endorsed the notion of congressional action in that area.
Good afternoon, everyone. Thank you to the Joint Center for inviting me to be here and to represent and provide some perspectives on behalf of Congressman Bobby Rush and all of his contributions to date with respect to the formulation of privacy and data security policy. And I also want to acknowledge the love and the shout-outs from Danny and from Jonathan for their recognition of the contributions that Congressman Rush has made, and the value that he places on the protection of personal information that relates to all Americans, but also to users of the Internet and of consumers who are members of communities of color. I want to say that his perspective with respect to the protection of consumer privacy reflects his ideas that legislation ought to be balanced, that it ought to be pragmatic, and that it also ought to employ tools that are flexible enough to permit that legislation to be as nimble as Mr. Barreca put it as possible, so that it is moving in tandem, so to speak, with developments that are occurring as part of the evolutionary wave of our e-commerce ecosystem. I have been involved with privacy policy and been in and around it now for the better part of 15 years. When I worked at the Department of Commerce as a younger attorney advisor in the National Telecommunications and Information Administration, it wasn't really rocket science to us at the time that data security would be very important to the development of the Internet, that policies that provided for duty-free or virtual duty-free tax treatment with respect to e-commerce, and the preservation of consumer privacy were all going to be integral to the preservation of consumer trust. And that by compromising on any one of those pillars, so to speak, we would run the risk of eroding that consumer trust and the willingness of consumers to make use of the internet and all the promise that it affords. I'm happy to say that we have moved beyond the stage of codifying, for the most part, the fair information principles, and that we are once again beginning to leaven the bread, so to speak. For some time, I think we have not really paid attention to privacy or accorded it the respect that it deserves because we have not been reminded of the repercussions that could obtain if you had mega breaches of the size and the order that we've seen recently, some of the privacy meltdowns that have occurred, exposing consumers to unreasonable risks, and also that fly in the face of their express choices with regards to how they would like for their personal information to be maintained and protected. Some would say that privacy violations do not amount really to tangible harms that should not be redressed under the law, that they do not leave a lasting stigma or permanent injury. I would say to you that I disagree pretty vehemently with that. True, many of these harms are not the types of harms that you might wake up with and that stare at you in the face if your identity has been stolen or if your financial account password has been hacked and people are out trying to take out credit in your name. But there are harms nonetheless which are validated really by some of the litigation that we see which has been initiated around the country. I won't go into some of that litigation nor will I go into some of the recent activity that the FTC has engaged itself in, hoping to hear some questions from the audience. But I will say that as information does get aggregated and as digital dossiers are compiled on each of us with an eye towards predicting our future movements and our behaviors, whether it be for the purposes of advertising, marketing, for research, whether that's political or consumer research in orientation. There will be times when that collection of information can be used against you in a way that would cut against your personal interests. I think that's probably a good place to stop and move it on over to Josh.
Thank you. Thank you very much. And Nicole, thank you very much for having us here today in the Joint Center for all of the incredible work it does in so many aspects of this space, and so and for organizing today's event. I think, and when I work for Chairman Janikowski at the FCC, and we see this as an incredibly exciting time in the technology space. It's a growing time in the technology communications infrastructure, and if you there's obviously a lot of tough news in our economy right now. In the broadband economy, there is a lot of good news. We know that there's a $68 billion and growing cloud service-based economy, growing 17% a year globally. McKinsey recently put out a study on location-based services showing it's now in the next 10 years going to be a $700 billion industry and the consumer side and the business side with all the value that's brought out of it. So and we see every day on the street and here, I think Danny started or Ms. John starting about the device. We all have devices, multiple devices. We have tablets. We have smartphones. So we know every day our lives are enriched by all this technology. And I think as all this massive innovation investment is happening, if we want it to continue, we must make sure there's a very good balance between all this personal information that's out there and all the consumer choice that's developing in the space, and of course, and the innovation investment. There is a tension here, and I think we have to be very careful to make sure that we keep the balance. And I know that everybody on this panel is working very hard to make sure that happens. We don't want to freeze out either side, and I think we have to really focus on keeping it balanced. I can tell you that at the FCC, we sort of, the chairman looks at this from a few perspectives. One, he's very focused on consumer control and choice, making sure that consumers are really in the driver's seat. Transparency, business transparency is critical to that. Personal information transparency is very important and not hidden, but actually truly transparent. And data security, a third factor that we must look at constantly, as was talked about in the data breaches that are becoming too much a part of our daily lives. And to make sure we get there, to make sure we encourage the continued exciting innovation in the space and make sure that we're protecting consumers, what the FCC is doing is one, enforcing the aspects of the Communications Act that Congress has asked us to enforce. Two, we are studying location-based services, which I think, as you talked about, it's every day. It's changing, and that's an area that just recently, I think it was a couple weeks ago, we worked with some of our friends at the FTC and pulled together an event where several panelists would come and actually talk about all the good and exciting stuff that's happening and all the steps companies are taking to look out for Americans and what else needs to be done to make sure that people are protected and empowered as location-based evolves. And because we don't want to kill it, we want to make sure that it thrives. So how do we make sure, again, that we keep that balance? And we're working toward a report which will be put out in the fall. We're doing a lot on the consumer information side, again, working closely with FTC. We have a joint task force. We're working as on OnGuard Online as well, and populating that with information and trying to drive consumers there so they know where they can get the technology they need and the information they need to make smart choices for themselves. I think together, if we all do our jobs, these agencies, and stay on top of and providing information to consumers, we can keep up the number one mission that we look at every day and wake up every day is about broadband and broadband adoption and getting people online because we know the benefits. People, if we don't, and that's where I'll finish, if we don't make sure we take these steps, the 100 million or so Americans, or approximately a third of Americans who aren't adopting broadband yet, one of the big reasons that we get back, and we know from a lot of the research that's done, and John Horgan's here who did a lot of the research on this for the National Broadband Plan, we know that a lot of people aren't getting online because they're concerned about their privacy and they're concerned about cybersecurity. And if that's one of the big reasons, we have to make sure that we take the steps to address that. So we encourage everybody to get all the benefits of broadband. Thanks.
I'm going to go ahead and pose the next question to Mark simply because you looked at me when you mentioned the word old. And the question is, I think there seems to be a consensus on this panel, and certainly there was on the panel before, that education, right, communicating to the consumers about what this is all about, what the tools are, what people are doing with their information, rather than identifying this is a harm you should be worried about, leave it up to the consumer to define what the harm is from their perspective. And I guess the question is, what are the sorts of policies that you think the administration, through the Department of Commerce or other agencies, should be facilitating? And if you believe there are those out there already that are being facilitated, please highlight them, that go to this issue of getting the education out there and getting it done. And I would love, once you offer up an answer for the rest of the folks on the panel, to also join in.
Sure. So I think that I have to pause a little bit before I share too much information, because we do have our white paper in development, and our white paper will address some of this. Some of these transparency questions, transparency in terms of how do you reveal to consumers when they need information about their privacy interests, how do you get it to them? The last panel talked about the challenges of providing that in a mobile space, the challenges of taking 9 pages of legalese and reducing it to something that's consumer friendly, irrespective of the size of the screen. So our white paper will provide some further thinking on how to simplify notice for the specific context. I think that's super important, is that people keep in mind that one of our big frustrations now is that the privacy policy is provided at a link down at the bottom of most pages, and the size of that link is in 3-point font or something like that. And I'm sure the woman who represents the older generation who is here on the prior panel, she would say that most elderly folks can't read 3-point font, so they have no hope of finding the policy, and if they find it, they'll be baffled by the legalese. So in our forthcoming white paper, we tried to talk about how notice in general can be improved, and in particular improved for the given context. Let me leave it at that. For one response. The other is, to keep at the projects that the FCC and the FTC have just talked about, which is the general consumer promotion of general consumer awareness, whether that's via On Guard Online or via any other tool. I think you need it both. I think you need both the general education, and then you need the specific education at the point in time when people are making decisions.
Danny? Jonathan? Tim? Anyone? Everybody's educated? All right, we are going to open it up to Q&A from the floor, but I did want to respect Nicole's instruction, which is she wants to orient this conversation, especially in this panel, around policies that are relevant to communities of color. And I wanted to tee off some stats that I know John Horgan and others have put out there, which is if you look at the rate of adoption among communities of color in the wireless space, it's going gangbusters. So the question I would throw out to this panel before we open it up to the floor is, are there unique policy considerations relevant to communities of color as you are trying to communicate to them about privacy issues and do some education in that space?
I'll go ahead and take this one, and it's something that we've actually thought a lot about. In the construction of our legislation, we have an area under the choice regime as to whether or not sensitive personally identifiable information is being collected. And we determined that if sensitive personally identifiable information is being collected and distributed, that you have a right, an opt-in right as opposed to an opt-out right to have that occur. And we had an internal debate about where ethnicity falls in that question. Is ethnicity sensitive information? And we determined that we needed to have a larger conversation with folks like the Joint Center and other people about that question, because there are a whole host of businesses that are based on marketing to people of color. And ultimately, the question becomes then, is it what our largest challenge was to establish a baseline level of information and power levelization between the person on whom the information is being collected and the person doing the collecting of the information. So as it relates to people of color, they should have a right to know if someone is marketing to them on the basis of their personal identifiable information, the fact that they're Latino, the fact that they're African American, and that might be okay with them. If they're being marketed because some combination of those facts, so let's say you're African American, low income, and elderly, and you're being marketed insurance or medical information, specifically because you fall into that category, they should have a right to know that and say yes or no on the basis of those things. So I think in the sense that people of color are disproportionately using mobile devices, then they might be disproportionately at risk to privacy violations in the mobile space. But one of the things that we tried to get away from in our legislation was the focus on either technology or choice in the sole context, because regardless of the mechanism by which your information is being collected, and regardless of the choice you make even, there are certain basic principles that must be respected. One, you should be sure that it's going to be secured. That's first and foremost. Second, you should have the right to know exactly specific purposes for why that information is being used and specific purposes for how it's being distributed. And whether or not you read the privacy policy, if we make it in law that you have to make those statements, then you have a legal obligation to live up to them. So the complexity of the privacy policy is really, for me, neither here nor there, as long as it establishes a legal obligation that you as the collector of information have to live up to that respects the individual on whom the information is being collected, because then the FTC can ensure that that privacy policy is lived up to, right? That's a deceptive practice if you don't do that. Currently, there was a little talk earlier today about whether or not the Joint Center should look through through company privacy policies and determine, which are good and which are bad. We actually have an agency for that. It's called the Federal Trade Commission, and they should do that. And everyone should have to have a privacy policy. If you look at the mobile app space and you look at the Wall Street Journal's study of the mobile app space, a significant percentage of mobile apps, of the top ones, have no privacy policy. And the question is I believe that's an unfair practice. I don't know if the Federal Trade Commission believes that because they haven't said so. So then the question becomes, Apple is clearly not going to take responsibility for the apps. AT&T has said they're not going to take responsibility for the apps. So who's taking responsibility for the apps? At the end of the day, we have an agency for that, and we should empower them to do so. And we should make sure that every collector of information has to live up to basic codes of conduct. Both the FTC report and the Department of Commerce report came to the conclusion that self-regulation wasn't working. Okay, so if it's not working, what's the other option? The only other option is if you believe people should have basic rights, is to establish a law that the Federal Trade Commission, the Federal Communications Commission, and the Department of Justice can enforce. So, I mean, I think at the end of the day, what we want to make sure is that while the fair information practice of choice, whether or not someone collects your information, is very, very important. It's just one of the multiple fair information practices that lead to a holistic protection of a person's dignity and respect, their ability to control the sovereignty of their self and present themselves to the world as they wish, right? If you have information about me, I should be able to access it. And if it's incorrect, I should be able to change it. And if I tell you to stop using it, you should have to stop using it because it's mine, it's not yours. And so nothing in law protects any of those things. So at the end of the day, what we need is a comprehensive code of conduct. And as long as we keep focusing on either technologies or one fair information practice versus another, we aren't going to fix the problem.
Catherine, any reactions? And Josh, I'll get to you now.
Well, I have to say that what I'm about to say is my own view entirely and not that of the commission or any individual commissioner.
Appropriate disclosures, absolutely.
But, as you can see from the white paper, the staff report that came out, those are issues that we're thinking about at the Federal Trade Commission. Privacy policies. We have brought cases in the deception area where people aren't living up to their privacy policies and honoring them, and there are questions about whether that's good enough. I mean, if there are other behaviors that aren't covered, perhaps by Section 5, what are the other tools available to us? With respect to also privacy policies from the staff report, the staff has found that those policies are pretty onerous. They're difficult to read. They're difficult to understand, and so we have advised that we would recommend that policies be made simpler, that there be a way to compare the privacy policies from company to company, so you kind of can look, and that can be another sort of competitive feature when you decide which service you want to use, which app you maybe want to use for specific feature. You can sort of look and use the privacy policy, and how they're going to protect your data, how they're going to share it as another sort of way to make your decision and be informed. With respect to what we're doing about minority populations, our overall privacy policies and initiatives are applying to all consumers, but we do kind of take a wholesale retail approach to consumer education. So we partner with groups like the AARP or the NAACP, different legal services groups, and try to give them access to all our materials so that they can get it out to their memberships. And we try to always be a presence at conferences and things, and that's how we're trying to get at those populations.
All right, let us pause and open it up to the floor for any questions. I don't see any questions. Gee, do we have a microphone that we... So I saw two up here, and then we'll get back there, okay? And if you wouldn't mind introducing yourself before you ask the question, that'd be great.
Morgan Reed, ACT. And as the Mobile Apps Trade Association, we're really seeing a renaissance of an explosion on the technology side for our membership. And the best thing that I'm actually seeing is jobs being created. It's been amazing to go to events for mobile apps where people are saying, I'm hiring, as opposed to I'm firing. So I loved, and I want to really say, we love you, Josh, for what you were saying out there. That's really true. We like to focus on that, which brings me to something that we are concerned about. The vast majority of the stories about privacy violations are not from my membership. They're not small guys inventing the next app. It's actually the big guys. It's Sony and Epsilon, and most significantly, and this is the question that I want to raise to Catherine and Jonathan, we had Google Buzz, which you guys did a settlement on, and Google Wi-Spy is something that Jonathan's boss spent a lot of time looking at. So my question to you guys at the FTC and with Blumenthal is, how do we make sure that you have the ability to go after the big guys who make the headlines, who are causing the trust gap that's harming my membership and their ability to do the kinds of cool applications and create jobs that we are doing and want to continue to do? So I guess that's, I mean, in a nutshell, how do we go after the big guys who are really causing the problems?
Well, from the FTC perspective, we've got, our sort of bag of law enforcement tricks, the FCRA Section 5 and the GLB privacy and safeguards rules, and we vigorously enforce them. So we're doing our best. If you have cases come to, I can't comment on any pending cases, as you know, they're all non-public, but we get cases in a variety of ways. We get them from the newspaper like other people, but we also, if you have a particular concern, we're happy to hear them. We're happy to field complaints. People write us letters, all the time. As quite, Epic often puts in, asks for formal requests for investigation. So if you have specific concerns, we're definitely open to receiving them. But I think, we do pursue, as much as we can given the resources we have, and so we will continue being, I think, our vigorous enforcers. So thanks.
Thanks for that question. I actually think this is a really good point, which is that, the technology, all these technologies are so new, and the nature of the problems are so novel to ordinary citizens that when you see a data breach or you see a story like, the Google Street View cars, and then you look at your device, it's not immediately separable to the consumer. How these different things are different from each other. And this is something that we've spent a lot of time thinking about in terms of our efforts to design legislation, is how do we improve, sort of consumer education around these issues, and also the transparency in the space, because, you can take Epsilon as an example. Epsilon is a third-party, marketer that that large retailers had sold on their mailing list to in exchange for them, sort of specializing in the production of these emails that you get every day from Best Buy. And so, that breach occurred at Epsilon and not at, Best Buy, not at REI. But, people didn't even know that Epsilon had their personal information. And all of a sudden they're getting emails from, BarnesandNoble.com saying, information has been, and it creates, and it really, the sort of lack of clarity in the space, I think, does a disservice to, the companies that are comparatively less culpable too, because, because there was no initial notification on the front end that information was being transferred over, it's harder for the consumer to absolve, that entity of responsibility for the breach that really happened somewhere else. So, and mobile apps are similar to that. So, for example, a lot of the work that Senator Franken and Senator Blumenthal have done around, mobile location privacy is designed to ensure that the consumer understands on the front end who exactly has what, where, so that, and that's sort of built into the notification, the consent policies, and the way that Mark was talking about, kind of at the point of contact and not buried in like a big 1,000-word document that nobody ever reads, just clicks through, right? So that when there is a location issue, right, or there is a data breach, it's clear sort of who had the information and where did that happen. And in the data breach space, that's something else we focus a lot on is when third parties have the information, who has to notify when, what does that notification have to say, do you have to explain in the notification what not only what information was breached, but why did you have the information in the first place, so that's if there's a less culpable entity in the chain, it's clear. So I think that this is a very good point, and something that needs to be built into the policy is a way to kind of encourage consumers through the structure of these regimes to have a better idea on the front end what the distribution of information, of their personal information is, so that on the back end they can better understand exactly what's happening.
Or Danny, do you want to add?
Yeah, there's a quick point I'd like to make here. One is the presumption of the question, if I may be so bold, is that there's a certain group of people who should not be subject to the concerns that we're expressing about privacy. That they are either not collecting information and not distributing it, and therefore they should not be subject to it, or they are so small as to not be harmful, and that the real harm occurs at the larger level. So in the construction of the Kerry-McCain legislation, as well as the Rush legislation, you're not subject to this law if you're not collecting, distributing information. You're not subject to this law if you're not collecting and distributing information on X number of people, which is a significant number of people. So I think we've taken those concerns into consideration, and we've taken the concerns into consideration about innovation and jobs as well. And the question that I have for industry then becomes, let's say you've taken all of those concerns into consideration, that you've constructed a balanced bill. At that point, does industry support privacy legislation? And some in industry do. I mean, we have the strong support of HP, eBay, Microsoft, some others who have some concerns but are relatively supportive. And at the end of the day, I think the question then becomes, when you talk to chief privacy officers at all of these companies, you're talking to some of the smartest, most committed people in their field. They don't become chief privacy officers by accident, or maybe they do, but then they grow to love it. And they really believe in it. They really believe that people, particularly their customers, should have a right to fair information practice principles. And then the question becomes, okay, so let's construct some and then make sure that it's not just your customers, but all Americans have access to fair information practice principles. So I think, again, we respect both innovation and the underlying questions about what is the relationship between innovation and legislation, or innovation and regulation. And at the end of the day, we felt like we've constructed a very strong, balanced proposal. So then the question becomes, if you do that, will industry step up and accept it? And we're still waiting to hear an answer from that in general.
Good afternoon. Want to thank you, first of all, for actually having this conversation. What I'd like to talk about, my name is Curtis Askew, and I run a data consulting company. And I want to get down to some of the nuts and bolts of policy around data and this issue of privacy, because it seems from the earlier panel as well as this panel, the starting presumption is that the best source of data is micro-level data, which is the person record, my personal cell phone usage, how I use it, where I use it, and the ways in which policy should be constructed around that transfer of information. It seems to me that the federal government, through the Census Bureau, has addressed this fundamental issue and has been addressing it since the 1970s. And it's a question of aggregation and how you aggregate the data. Why is policy then being structured around the presumption that micro-level data is something that needs to be passed from one company to the next, when instead, if companies were responsible and held responsible for aggregating the data up, then you're not dealing with the same sorts of privacy issues that you would if you were simply looking at micro-level data?
Just to respond from the Kerry-McCain perspective and what we were doing at the staff level, the fact of the matter is that there are a significant number of firms that do believe that micro-level data is very significant and important, and there's a sharing across both first parties and third parties that yields a whole host of information that firms then use in positive and maybe less positive ways to deliver services. So the question then becomes, by your suggestion, if you concentrate on aggregate information, which is what you're arguing has the greatest value, and it may have the greatest value, then you could either eliminate or ban or not allow the collection of micro-level individual information. Even if that were true, there would be a whole host of people who would disagree from the practices that they engage in, where they are actually, and if you look at the long tail of the internet, a lot of that information is niche information. And the delivery of services is very niche delivery of services. And that has value for the folks in those niches to receive that information. So the question then becomes, is there a way to do that and deliver those services in a way that's really ethical, that respects the individual and allows them to participate and know in how their information is being collected, how it's being used, and for them to be able to say yes or no, right? And to make sure that it's correct about them. So at the end of the day, I think, this is a strange year for legislation. It's a strange year all around. But we're developing a sort of a body of work over time, which started way back when I just started working on this in the late 90s, and has built up through today. And we're developing a general consensus around what fair information practice principles are, and the fact that collectors of personal identifiable information should respect them. The question that it becomes really complicated and hard to codify that. And so it's a long and complicated discussion to make sure that we write it correctly. And there's been really good participation in that process, and I don't expect it to go away. There will be another Congress and there will be another FTC, and the conversation will continue progressing.
Anybody else want to react to the question?
If I can react to it, if we were to assume, I guess the predicate of what you're saying is true, we probably wouldn't have a free internet to show for it. That microdata does have value, and I think what consumers don't really understand is that their data is a form of currency, which has paid for and built the internet that we all know, love, and rely upon. And just segueing back to the question that Nicole posed with respect to personal information in relation to race and ethnicity information, we approached the question of sensitive information a little bit differently in looking at the breadth of that definition. While we are cognizant of business models that have been constructed to depend on and to monetize information and the marketing tendencies and predilections of minority consumers per se, we would still think that there is incumbent upon those entities that deal with that information, whether it be race and ethnicity, religious beliefs and affiliations, sexual orientation, or sexual behavior. Too often those characteristics, those labels, have been used in the offline world to perpetrate discrimination against protected classes. So there's really no reason to think or to question why similar practices could not be perpetrated in a virtual world. So, I hope that gives you some insight into our thinking with respect to that question.
So we are technically at the 1:30 spot, but because the first panel went over a little, I'm going to take the liberty of asking, do we have one more question from the back, or is there anyone else that has a question?
Hi, I'm Baron Soka from Tech Freedom. I just want to ask about the trade-offs involved here. I'm a little concerned to hear Daniel talk about a consensus here, because I don't think it exists. I think there's a really fundamental difference of opinions here, and it comes down to the kinds of things that you were talking about. For example, access and correction rights. I actually think that if you ask people who follow this, there's a pretty big disagreement about whether it's a good idea to create access and correction rights for all data, understanding that that essentially requires authenticating all users, and you lose at that point the experience of browsing the internet, and instead require that you authenticate someone's access to see what information you have about them. But more fundamentally, I think there's a big question here about free speech. I, for example, right now have collected all kinds of data about all the people in this room, and I have a right to do that because we believe in this country that we have a right to collect and use data, and the Supreme Court has just upheld that principle in the Sorrell case. And I think we're going to see a long line of cases coming out of that deal with how we reconcile the protection of data that the First Amendment offers with privacy concerns. So my question is, the Supreme Court's already hinted at a way to do that, which is you establish a real harm, a real government interest, and you look for less restrictive solutions to deal with that. And what I'm hearing today, unfortunately, is there's an illusion to that there's a real harm here. Tim said that there were real harms, but didn't have time to get into it. I'm not sure what those harms are. If there are real harms, I'd like to hear what the narrowly targeted solutions are for dealing with those problems. And I don't understand why we're rushing to, because there are some harms, rushing to across-the-board restrictions that put at risk all the many benefits of data. Because it's not just revenue, it's innovation. And it's things like Google Flu Trends, for example, which is a service that's built on unanticipated uses of data. Or, since we're talking here about the disabled, I mean, I'm somebody who has had personal experience of having to use voice dictation software, having had both of my hands out of commission for a long period of time. And that software has been improved precisely because companies like Google were able to use huge amounts of data that they collected for other purposes to improve voice recognition algorithms. So I just want to know how you expect to be able to continue to get the benefits of that sort of innovation, as well as the revenue that supports free content, if we're rushing to impose across-the-board baseline, as some of you have said, comprehensive privacy regulation, and whether we shouldn't look for more narrowly tailored solutions to clearly demonstrated problems, such as we had with the Fair Credit Reporting Act.
A couple of things, and thank you for your question. In terms of what the consensus is, I was talking about the idea that there's a consensus among people who are expert in the field of privacy around what fair information practice principles are. Now, yes, there is a division of thought both among members and in the community about how you, or whether you should make those fair information practice principles law and requirement writ large. You take, for example, the access and correction rights, which you listed. So the question becomes, should people have access and correction rights? If you impose them, then that imposes a cost, and what harm are you preventing by imposing that cost? In the first instance, if people are going to collect information on an individual, make decisions about that individual, and relate to that individual in a specific way based on information that they've collected about them, then that individual, as a function of ethics and commerce, should have a right to know what that information is and ensure that they're being treated in a manner according with accurate information. So we did provide access and correction rights in our bill. But we also said that if the collector of information determines that providing access and correction to folks is too expensive for them to do, then the individual would have a right to say, fine, don't tell me what you have on me, don't tell me how you're using it, but don't use it anymore. Then the question becomes, the question becomes whether or not that is a fair request to make. Should people have the right to say to companies that have information on them, are collecting and using it, to say, please stop collecting and using my personally identifiable information? And the answer to that question, we believe, is yes. You can have an honest argument about whether or not that's the case. But there are a whole host of companies, from eBay, Google, Microsoft, Hewlett-Packard, Intel, plus a whole host of folks in the consumer community who agree with that question, that perspective. So, and that's the reason we have a Congress, that's the reason we have deliberation, and we'll continue to deliberate that question. But the innovation in privacy legislation not only need not be in conflict, it is the presumption in the FTC report, the Department of Commerce report, and in our work, that if you establish a baseline code of conduct for how collectors treat people and their personally identifiable information, that it will encourage participation in the market, and it will encourage consumer participation. Now, you may not share that view. That's fine. and we have a deliberate process for that. But there is a general consensus among the agency experts and among people who work in privacy writ large around the world on what fair information practice principles are and whether or not people should abide by them.
Tim?
Yeah, thanks for the question, Baron. Baron is a very one of the sharper minds when it comes to privacy policy, and I want to thank him, for the question. He often offers constructive thoughts, so I appreciate the spirit in which the question was offered. I would say that privacy violations do present tangible harms. No fewer than 10 states have enshrined the right of privacy to be so important that they've included in their own state constitutions. Now, presumably, we didn't have this electronic network of networks known as the Internet when those constitutional provisions were enacted, but still, that is nothing I think to sneeze at. To look at privacy harms just from the standpoint of the individual, I think is also wrong-headed. As our moderator's colleague, I believe Professor McDonough, has pointed out, there are externalities involved as well. Privacy abuses can harm the collective. Even if a particular violation is not cognizable, for example, if a website is collecting my information and using it in contravention to what they notified me would be the particular uses for which it would use that information, I may not experience a harm at that particular moment in time. But once that is discovered, that can certainly have an impact on my future decisions with respect to whether I want to use that particular website or that given a social network. And in fact, if the practices that are perpetrated by that particular website or social network, for example, are so egregious enough that they can have secondary and tertiary effects on future business plan modeling for firms that may want to go into that particular sphere of activity, that is a very tangible harm that affects not only the individual but the general economy.
So with that, I think we are done with this panel. Please join me in a round of applause for our speakers.
Thanks, Carolyn. And before we break, I just want to leave you with a couple of closing remarks. First, I want to say thank you to both panels. The first panel was very helpful in giving us a framework for how we should look at policy. The second panel was very helpful, I think, in really talking about the policies that they are actively engaged in working on. One thing I want to just leave you all with as to, again, why the Joint Center cares about this issue. Today I woke up to a report of statistics that came out of the Department of Commerce today, the U.S. Census Bureau, around the wealth inequities that exist between white Americans and black and Latino Americans. And the gap is tremendous. It's 100,000 from the state of white Americans to less than 5,000 of net worth for African Americans. And when I woke up this morning, I was saddened by that because it shows us at the Joint Center how much further we have to go to actually fight and win this battle around making sure that we don't see this widening gap of these social issues. Privacy Though broadband offers a platform for economic promise and social opportunity for many of these groups, if we don't address these forthcoming issues like privacy, and we don't see how they actually contribute, as Josh mentioned, to broadband adoption and ensuring that people can close the wealth gap, then guess what? We deepen the concerns, I think, that we're currently seeing around this wealth inequality that's actually surfacing. So I put that out to you all. You may not make the connection. I do, because I do it every day and I see it. But I think we have to be very conscious that the pathway that we put forward, as it was said in this panel, honors the privacy of consumers, respects their integrity, and does not have an unintended consequence going forward. And I think with that, as we heard in the first panel, we also need to be clear that we do not put regulation in place that stifles the innovation that potentially includes more people into this ecosystem where they can break the trajectory of poverty, of isolation, and other factors that limit their ability to be full participants in our nation. So I put that out to all of you. Please follow the Joint Center on our website, follow us on social media. Again, thank you for all of you participating, and we will follow up this conversation with more conversation.